My lord, there is one matter related to 10 marks. On 6th November, it was mentioned, and as per your lordship's direction, this matter was to be listed today, but it had not come in the list. My lord,
Matter whatever order is passed will cover you.
my lord, if the point, my lord, if the points in the repetition is not placed before your lordship today, then with this all matters, then it will be loss for the petitioners and the applicants, my lord.
Wait. Please wait. Matters will appear in due course. Do not worry.
My lord,
Same thing, 10 marks.
I also know, my lord.
Same matter.
Addition of party in our matter, my lord.
The main matter is not their addition of party.
My lord,
Is the oldest.
my lord, this is the oldest matter, my lord. It has been filed in September, my lord.
Yes, there are other matters also.
Yes, but this has not been.
Matter.
This is
It will appear. Give the number. They can
lord.
not come. It has been
My lord, I'm sick.
requisitioned. They can check in a WB number 10 in same WB number.
Yes, same WP number.
Lordship.
Same WP number.
My lord, kindly take the matter today, my lord.
24th in this month. Earlier page fixed the matter on 24th in this month, seeking direction so that it will be appear on 24th.
Advance direction.
My lord, yeah, come to know that file say already sent out. It will
What
take
can
the-
be done? If it has sent down, it will come up.
My lord, I'm seeking leave to urgency to file the writ petition. My lord,
Urgency.
this is the OMR regarding the second SLST discrepancy in the OMR. 17th is the possible date for interview. My lord, if your lordship kindly allows us to
Discrepancy in OMR, 1 second. What is the issue?
OMR regarding the bubbling issues.
Yes.
My lord, kindly keeps it on Friday, my lord, so that can this 48 hours requirement kindly be condoned, leave may be granted so that it can appear on Friday. And I can serve on Thursday and can Friday.
Thursday is tomorrow.
No, I can serve it, but kindly keep it on Friday, my lord. That is right. Because 15, 16, Saturday.
Okay, other matters have been
No.
fixed. I will not
Then
fix
tomorrow,
it
my
on
lord,
Friday.
15, 16, Saturday, Sunday.
Nothing doing.
That is the difficulty.
Saturday, Sunday, let it remain.
There is Monday, my lord.
18th,
17
Tuesday.
possible is the date for document
Whatever
verification.
will happen, will happen.
My lord, kindly 17th, my lord. 17th, my lord, at least, my lord. Because
Correct, 17th.
leave may be granted.
My lord,
Giving the number for 24.
Please don't give the number. Wait.
my lord, kindly permit that.
Panel cancelled, my lord, some teacher has been reinstated in their previous school, but they have been posted 150, 160 kilometer away. But you will not teach a bunch of matter to know. They have similar matter, but can you
Again tomorrow.
so same issue, my lord, same issue. One matter decided, everybody is go.
All right, tomorrow.
My lord, kindly permit that the matter will be heard today, my lord. My lord,
Madam,
kindly
the
seniors
matter
will be
is not there
appearing.
in the
My lord,
list.
The supplementary
Please
list,
wait.
my lord.
my lord, kindly, my lord.
Please wait. No.
Lordship, a matter filed before the Pujo vacation and the matter till date is not in list. So, Lordship,
What were you doing when all matters were allowed for inclusion? You cannot come up any day. Right? So please wait for your turn next month.
Lordship, 6th of November.
No.
Lordship, the unmarried daughter's pension, Lordship, it was heard and directed the elder sister to file an affidavit before this court. And it was directed to appear on 7th November. Lordship, it has not been listed. Lordship, kindly consider.
Yes.
I am seeking leave to file this writ petition, my lord. Identical writ petition, you will also be pleased to fix on 14th, my lord. This is, my lord, regarding the getting of 10 marks for prior teaching experience with regard to the contractual teacher in central government school. Your lordship has been pleased to fix the matter on 14th, my lord. This matter will be kindly taken up with
This
that.
matter will be taken up on the 18th. Whatever order is passed on 14th will cover you. Right? 18th it will be taken up.
My lord, there is another matter. On the earlier, in the earlier occasion, earlier bench had passed the order that it will come in the list on 11th November, but it has not come. My lord, this is an urgent matter. The upper primary selection process and the counseling is going on.
Yes.
And there are two matters was to be listed yesterday, but it has not come.
Taken into it.
The notice had been
All right,
served.
call the list, please.
Grateful.
I was seeking leave to file an petitions pertaining to the determination of the circuit of service. Being affirmed, unless the leave is given, it will not be affirmed.
Circuit bench is not there this week.
newspaper discovered.
What is the urgency?
Urgency, the recommendation was made, appointment letter was given. Well, I was not allowed to join the schools. Only the ground, the validity period of 90 days expires.
Yes.
The court directed to consider and giving the
No,
observation.
I am not giving leave. File it in the circuit bench. It is not so very urgent. The issue is already being decided. It is urged before this court. So whatever will happen will govern you. File it in the
Well, it is being considered.
circuit bench. Yes.
May it please your ladyship, beg to appear on behalf of the applicant in the contempt application. There was a direction for service. Service has been effected, my lord, upon all the contemners.
Is anybody appearing for the contemner?
Mr. Bandyopadhyay is appearing. Yes.
Yes, your lordship. Your lordship, Mr. Bandyopadhyay is leading me, your lordship. I appear on behalf of the speaker.
Oh, he's coming. What is the violation?
But I'll be praying for issuance of rule of contempt because
What is the violation?
yes,
Tell me.
your ladyship kindly takes the order, solemn order dated 28th of August 2025 at page 16.
Yes.
Here, my lord, the learned Advocate General had filed a report whereby the speaker replied, my lord, to the query of the Honorable Court via the Secretary of the West Bengal Legislative Assembly. Now, there it was stated that all the MLAs, my lord, the members of Legislative Assembly are being treated equally and no one is being permitted to enter inside the premises with the security, personal security officers. Now, on the basis thereof, my lord, the writ application was disposed of, recording at para 9 that all the members of the Legislative Assembly shall be treated equally. And before that, if your ladyship kindly also takes, my lord, para 7, 5, 6 and 9, para 7 especially, as the Secretary West Bengal Legislative Assembly has intimated the learned Advocate General that the security arrangement is maintained equally for all members of the Legislative Assembly, irrespective of their political affiliation. Accordingly, this court is not inclined to proceed with the writ any further, though the maintainability was sought to be urged, such and such. The instant writ petition stands disposed of with the observation that all members of the Legislative Assembly shall be treated equally. Now, this solemn order, my lord, was immediately communicated on the 29th of August. The communication was made, my lord, to the Honorable Speaker, the Secretary of the West Bengal Legislative Assembly, the Director General and Inspector General of Police, the Commissioner of Police, as well as the Director of Security, stating that this is the solemn order and you are hereby required to act strictly in compliance with the order. Now, pursuant thereto, at page 20, the Assembly House published a notice dated 30th of August that no one will be allowed to enter inside the assembly premises with the security. Now, this happened on the 30th, but peculiarly, my lord, on the 4th of September, but I have pleaded it in para 5 and 6 of the contempt petition, but no one was allowed, my lord, to enter inside the assembly premises with their security, my lord, the legislators of the opposition, party in opposition, whereas, my lord, the MLA, my lord, from Bhawanipur Assembly constituency, who also consequently happens to be the Chief Minister of the state, so she entered the assembly premises with an entire security detail. There was no obstruction, nothing, my lord. We have also enclosed, my lord, at page 22, my lord, the newspaper report, and we have also, my lord, furnished, my lord, along with the petition at page 23, my lord, the pen drive containing the video footages, my lord. So this is, my lord, I say, my lord, it's an attempt, my lord, to mislead the Honorable Court, my lord. It's a deliberate attempt because our case was, my lord, throughout in the writ application.
All right, I have followed your.
My lord, Learned Advocate General will like to address your lordship, my lord, on this contempt application. He was requested to, my lord, either pass it over if it is possible for your lordship, my lord, because it's an Orion side matter, my lord, we are conscious of it. Or, my lord, if your lordship takes it in the coming week, my lord, or Wednesday or Thursday, because he's addressing the adjacent court, my lord. He's on legs.
My submissions are very
As far
limited,
as
my lord.
for the contempt number 1 mainly, 2, 3, 4, my lord, we'll also address your lordship, my lord, may not have any role in the contempt at all. Because your lordship had heard a bit of the matter, my lord, and the powers ultimately will lie with
The
the speaker.
order is very clear.
Yes,
It was relying upon the Advocate General's submission that this
Yes.
ensure that this order is complied, nothing more.
But we'll come back with our, my lord, kindly takes it next week, my lord. This probably will
Yeah, please
require.
come.
I'll be praying for issuance of a rule, my lord, on the
When
contempt
somebody
number.
is appearing, then
Very-
what is the
very-
use of the rule?
Very
Mm. Third submission made on behalf of the petitioner. Stop. Learned advocate representing the alleged contemners seek accommodation on the ground of the learned advocate general. Stop. Next Wednesday,
Wednesday.
19th.
Grateful.
না না আমি আগে বলে নি তোমাকে তো তাড়াহুড়ো
But in any event, the learned advocate general will come and seek the.
No, I'll make my
No,
prayer. You
first
don't
is
make
for-
the prayer on my behalf.
In terms is no, I am just indicating the law. You are not supposed to
No, no,
indicate
no, what you
what I
want?
am indicating.
What you want?
We'll come
No,
back
but,
on the Wednesday, my lord, and we'll
my lord,
make our
The
submission.
procedure is, my lord, they will come and my lord seek for an affidavit. So my lord can, my lord direct pass filing of an affidavit.
If required, we'll seek on the next day, my lord.
Not today. Let us not jump steps. Let him come.
Grateful.
I appear for the.
বলছি যে এটা অডিয়েন্স তারপরে এক নম্বর আমাদের
But I have given notice to the other side. The last day also.
Well, in this
My
matter,
affidavit of service.
Mr. Bari is appearing on behalf of the respondent number 4, 5, and 6.
School.
But I'm school. But I'm praying for Passover. But he's coming. He was here.
Let me start then.
Let him start.
But I'm questioning
For the
the
state.
the state has no role in this matter because the de-getting school where I'm working, the difficulty is
Mr. Bhattacharya, please. As it is, the courtroom is very small and with so many people, it becomes difficult. Yes.
I was appointed in 2010 as a teacher. I was confirmed in 2014. The difficulty is but I'm not on that. I'm on the issuance of show cause notice and the charge sheet. Kindly turns to page 50 to 97, page 51. But what is my challenge in this petition? Charge sheet, your lordship will find at page 50.
Yes. Charge sheet.
Your lordship will find page 51. Then kindly turns to page 52. But the charge number 1.
What is the stage? 7th April, I can see this.
Yes. Thereafter, continue. I question this charge sheet on the point. Kindly turns to the charge number 1, last line. So, it misconduct on your part in terms of para 10 of geo number 214 dated 8th of March 2018. Wait a minute. Now, I tell you, lordship, this is the rule for disciplinary proceeding. Kholo na.
Yes.
For the teachers working in the government aided institutions. This is a de-getting school. This rule of 2018 disciplinary rules is not applicable in cases of de-getting schools. This is number 1.
I need the state. Who's for the state?
May I show the law first?
Who is for the state?
I have given
Service.
this to the other side, but kindly see who appeared for the state. Order sheet is
No, order sheets are over here.
Well, the AOR has been put on notice.
Give one more notice. Come back. Please come.
Can I interview? No, let him give a notice. I will appeal it. Kindly keep it in the list.
All right.
I will.
Accommodation has been sought for on behalf of the respondent numbers 4, 5, and 6. Stop. Release the matter next Wednesday.
Next.
This one number 4, 5, and 6.
দিয়ে দাও চিঠি দিয়ে দেবে চিঠি দিয়ে দেবে
mentioning over.
Yes. Item 1.
Mentioning.
My lord, I'm appearing for the writ petitioner. The writ petitioner has requested to withdraw the writ petition.
Let me see the request.
Yes. Yes, your lordship.
Are you the advocate on record?
No, your lordship.
Diggy? Let me see. Release, non-prosecution. Dismissed as not pressed. Yes, give your name. Your name.
The slip.
Non-prosecution. Application which for
Petition, if it is disposed, consequently all application stands dismissed. Yes, two.
But I appear for the petitioner, same. This is my
Not press. All right, not press.
the written instruction.
Yes.
On the Bhattacharya.
I am appearing for service commission. But I think Mr. Bhattacharya, the matter which was arguing, if Mr. Bhattacharya is there, it can be taken up at first. The matter which Mr. Bhattacharya was arguing.
He is arguing same thing. Is it?
Yes,
the
yes, 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 yes.
It's the same matter.
Same matter, my lord, item number 3, 4, that is filed before, my lord, even start of the online application.
No, I have no difficulty. I am saying that only if the Mr. Bhattacharya which has comments, whether you will lordship will take up same branch, same list.
Yes, yes.
Mr. Bhattacharya is here now. He said he will argue.
Court number 13.
Okay, you can start. There's no difficulty. I had a talk with him.
He'll come, he says.
But only one thing that your lordship wanted to know whether these points have been taken in the Supreme Court or not.
Yes.
Well, kindly see this. Look, give it. All
Prepared all these orders. All right.
And this is
Is that the compilation?
This has got all the orders of the Supreme Court.
Or Supreme Court and
The rules.
and Miller.
All right.
কোন প্যারাগ্রাফ প্লিজ আমার কাছে তোমার কাছে সফট কপি দেবে মানে কাইন্ডলি টেক দিস
Is this the same compilation? One has been handed over. This is separate. But the orders will be the same possibility.
compilation
Page 180.
page 181 page 181 of the compilation তাই তো কাইন্ডলি কাম টু গ্রাউন্ড কোথায় আরে ভাই ওরকম ভাবে হয় না ইউ নো এভরিথিং দেন ইউ আর
Give the copy.
very nice I will know don't please don't show to your temper Mr.
Listen, it is the first matter in the morning.
No, I am why he is showing this
No, he wants
Soft
to
copy.
know what you are relying
but I am
on.
saying I was sending him to soft coffee
Whatever, let him know at least.
yes I am sending him to soft coffee
Yes.
even then he is shouting
Yes.
but kindly come to first ground number 8
Which page is it? 181 is something else.
241
241.
it starts from that
All right,
241
241.
kindly similar
Ground number 8.
whether the Honorable Division Bench of the Honorable High Court of Calcutta have failed to consider that in gazetted notification the schedule 2 10 marks will be given for prior teacher. This point is newly added and with intention to accommodate those who are working as a contractual teacher in a private instance. So the benefit will not be given only to the untainted teachers. They have lost their jobs due to the fault of the school service as well as the state government. So by adding this clause, the state government are going to recruit the contractual teacher by allotting 10 marks extra. Next, my lord, ground 15. Page number 244.
Yes.
Whether the Honorable Division Bench of the Honorable High Court at Calcutta have failed to consider that this Rule 2025 is a perfect legitimate means for arbitrary whimsical action of authority. The authority cannot create any special class of people to give any extra benefit by way of experience marks. This rule has not a hint of reasonableness. The protection provided under Article 14 of the Constitution of Indian Constitution is also denied by this notification date 29th May 2000. That is the said rules of 2025 and the notification date 30th May 2030. The administrative further the authority arbitrarily whimsically can make the rule 2000 decide that the selections process will be held by following the 2020 thereby failing to provide equality before the law and equal protection of the law, and therefore notification so and so said rule that the advertisement are unconscionable, ultra-vires and so and so. And my lord, kindly take in
Take one thing.
ground 7 also.
1 minute.
Hmm.
These grounds
Huh.
are challenging which order of the
That's the order of the division being presided by Justice Soman Sen.
all right.
Millard, kindly come to Millard once. I'm sorry.
Page 194 is the order possibly?
Page, yes, page 194.
In terms of page 136.
No, main order.
196.
Millard, main order is 196. Mr. Bhattacharya's argument.
196.
Millard, and you see, Mr. kindly come to 199. Paragraph 6.
Yes.
Mr. Bhattacharya has submitted that the finding, observation, and directions contained in the aforesaid orders are to be strictly followed. The notification of the WB SLST does dated 30th 2025 insofar as its attempts to fill up further vacancies would be in clear violation of the aforesaid directions and are not permissible. Mr. Bhattacharya further submission, there has not been significant change in the rules of 2000 which would render the present applicable. It is submitted that the prior teaching experience for 10 years was not an eligibility criteria in the earlier. Moreover, the percentage so and so 48 with a clear malafide intention to make the present appellants disqualified, and otherwise qualified candidates in terms of the orders mentioned above would now be not allowed to participate under the rules of 2000. The present notification and rules are intended to and tailored sorry to exclude the candidates qualified to participate under the recruitment rules of 2016. Moreover, all the appellants, most of them have become overaged by the time limit and disqualified under state rules of. All the appellants are victim of circumstance unless the state rules of said rules of 2005 is set aside and or the present appellant would lose valuable rights and have accrued in their favor under the recruitment process. Mr. Bhattacharya has strenuously argued that neither the order of the Honorable Division Bench nor to several orders of the Honorable Supreme Court has limited the participation to the candidates appointed in the state selection process of 2016 in the process. It is submitted that the word used are candidates in paragraph 45 and 5 of the judgment which would include the candidates participating in the selection.
This is not relating to 10 marks.
No, not relating to 10 marks. Now,
Miller,
kindly come to the judgment relevant portion which is the finding, kindly come to finding.
Internal page 22.
Internal page 22.
But my lady, may please see
this was placed.
Huh?
This was placed before.
Mala, kindly see page paragraph 18 also.
State's reply, page 205. It pertains to prior teaching specifically.
It is submitted that when the expert committee has formulated the guidelines relating to recruitment of teachers, unless it is established such change of policy would be in clear violation of statute or constitutional provision, or arbitrary decision of the authorities are to be respected. It is submitted that the rules relating to prior teaching experience was one of the criteria in the notification dated 2026, and it has been reinstated in the recruitment rules of 2002 to ensure quality teachers in teaching standard. Whether the recruitment policy of 2016 is better than the recruitment 2025 is not a ground for declaring any of the rules as ultra-vires or to be interpreted as one. So, this is a submission. Now, kindly come to finding.
19 and 20.
19. Now, in so far as the variation in marks criteria is concerned, Mr. Advocate General submitted that NCT is the expert body to fix up the criteria for teachers' eligibility. In our country, revision is requirement in make marks pursuant to NCT guide. But what I am submitting, this argument has been made. Then, now, my lord, that's the argument. Now, my lord, kindly come to submission. Come to relevant portion of paragraph. I'm just showing you relevant portion 24. Mr. Bandyopadhyay has justified the awarding of 10 marks for prior teaching experience on the ground that it is also extended to the teachers who have taught in schools under Kendriya Vidyalaya Sangathan, Navodaya Vidyalaya Samiti, State Council of Education Research and Training, West Bengal, and other government-sponsored schools. Marks for prior teaching have been provided with a view to appointing experienced teachers who will be able to teach students in the regard he has relied upon the decision of the Honorable Supreme Court, so and so. This is an intelligible differentiation between the unsuccessful candidates and in-service teachers, which is the writ petition have sought to well from the Honorable Court in this proceeding. Then other arguments, this is not relevant now for the timing. Now, my lord, kindly come to paragraph 34. The policy. The awarding of 10 marks is an weightage to be given on the basis of experience, and if it is only expected that in a selection process of the nature and kind, all the candidates are required to undergo the rigorous of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. The object is to select and appoint experienced teacher, as rightly pointed out by the learned advocate general, Mr. Bandyopadhyay. Since appearing on behalf of the commission, the appellant are not coming within the purview of the categories in whose favor, benefit, and consents have been extended in paragraph 49 of the judgments of the Honorable. They are not the candidates selected in the 2016 recruitment process. In the meantime, they have not also applied for service in any educational institution. It shall be the duty and responsibility of the state to ensure quality education, and the eligibility criteria should be framed keeping in mind the interest of the students. If we accepted the submission of Vikas Ranjan Bhattacharya, learned senior, for the selection for the same subject, teacher, two different eligibility criteria has to be applied. The eligibility criteria in the selection process of 2016 is different from the recruitment process of 2020. The rules are more stringent and student-centric. The revision in the eligibility criteria is in accordance and consequence with the NCT guidelines. NCT is an expert body to fix the criteria. NCT is the statutory regulator for teacher education in exercise of powers, so and so. It makes regulations specifying wrongs, so and so. The commission has followed the state guidelines prepared and recommended by an expert body. There cannot be any compromise on the standard prescribed by the NCT. Education system will fail if we compromise on inequality, so and so. All recruitment rules must present eligibility criteria. This is then. Will not kindly come to next page. Page 219. This
paragraph they mention no rule challenge.
Will maybe teacher for the this will yes. Line 4, kindly see. The prior teaching experience is an important factor, as experienced teacher may impart education for effectively and efficiently. The recruitment rules 2025 has not been challenged by any of the applicants. The delay in the fresh recruitment is due to the pending litigation, and when the opportunity for employment is open by always open for the authority to decide the eligibility and other criteria in the academic interest. And for the benefit of this, we accept the submission on behalf of the state respondent that there was no specific direction in the order of the Honorable Supreme Court by which the state is obliged only to fill up the declared vacancies on first SS1. So this is going. Now come to paragraph 35. First, if the government felt if the government felt that the experience gained by the candidate is relevant, the court cannot take a different view in judicial review. Similarly, percentage, any age limit for a given post, and also deciding the extent to which a reduction can be given to the state age limit are essentially matters of policy. The criteria laid down by the recruitment process 2000 was intended to select the best of the candidates. The right to education guaranteed in terms of Article 21 clearly envisage quality education being imparted onto the children, which in turn would signify that the teacher must be meritorious and the best of the lot. Any process which applied equally to all the candidates and was designed to garner the best talent cannot be called in arbitrary. But although at the top of the judgment, although it has been said by Mr. Bhattacharya that no, we are not challenging the rule, but at the time of argument, he has dealt with all that. He made all these arguments. And kindly take the judgment in order of Justice Shogata Bhattacharya. That is very important, Miller. Point is this, Miller, point has been taken. Thereafter, if any challenge has been made, argued in one court, then the higher court, some points should be, that is the case of abandonance. That is not the case that point has not. Kindly take, Miller, Justice Shogata Bhattacharya's judgment, page 128. Kindly come to para 5.
Page 131.
131, right. Right. Challenge has been, my lord, challenge has been thrown to West Bengal School Service of Selection for appointment of the post of assistant teachers for upper primary level of classes so and so rules, and recruitment notification dated 13 issued by the secretary so and so. Mr. Bhattacharya Anastina representing some of the petitions submitted in terms of judgment. Then para 5, you'll also see it is clear the challenge, whole challenge of the rules was there. Then kindly come to me, Lord, paragraph 10. Paragraph 10, yes. It is submitted. Yes. Another limb of submission made by Mr. Bhattacharya is against some of the provisions contained in the said rule of 2025. It is submitted that recruiting authority ought not to have altered the provisions relating to fixation of 50% marks instead of 45 marks, which is in earlier recruitment rules in graduation. But just pause for a moment here. Here, the Honorable Supreme Court has safeguarded that this 50%, that only 45% would be there. There was an interim order, which is in earlier to be alleged as eligible. According to petitioner, distribution of mark, that is 10 for prior teaching experience, 10 for interview, and 10 for lecture demonstration, or not to have been provided, which would give in the recruitment authority and the interview board unbridled power to allot marks indiscriminately. Therefore, this point was taken before the learned single judge. Although Mr. Bhattacharya has started before the division, we know we are not, but here he has made the submission. And before the division bench, while making his submission, he has made argument why the 10% marks are arbitrary. Therefore, his submission that no, I am not challenging, that is not reflected ultimately from the judgment. Now, against this, all this Supreme Court, SLP, etc. filed. Now, WB Sadhu Khan, which I have shown to your Lordship, he was not a party here in this matter. WB Sadhu Khan preferred the SLP directly against this judgment. Against both this judgment. There, I have pointed out to your Lordship regarding the points regarding 10 selection. May I just, she is also here, she knows, she is here, I am also there. I just informed you, the Supreme Court has said that we will examine all the issues. Matter has been kept on 24th and 26th. Therefore, that kindly come to page 263 of the compilation. Kindly see status. But order was also passed. Yes, a matter will come up on 26th, date has been given.
The petition in our compilation. I'll show my lady.
Therefore, I have, at the threshold, I have said so that your Lordships can now you decide whether your Lordships will decide the matter, or otherwise I am ready for making all my arguments here.
Sim number 9, the point that I have taken was that your Lordship has gone through these all the orders, where these 10 marks are to be given and whether I have not challenged the rule, and whether even if the rule is taken to be valid, whether 2016 candidates whose appointment has been declared null and void would be getting any marks. And for that matter, only one judgment of the Supreme Court in
No, এখন তো মিনিটে আসছি না।
like to place. My lord, Lordship,
We'd like to
We'll go one by one.
Yes, we'd like to finish our submission this side and then go to that.
And if your Lordship wishes to hear the main matter, I have no objection. But I just tell you, Lordship, I am making a submission.
But then more or less, whatever your submission is, you have made, that this is all right, it can be done. Division bench's order is in your support. This is more or less your argument.
And another submission, my lord, that your Lordships, the law is very settled. That is the binding precedent of the division bench.
Yes.
And very recently, Justice Bagchi has delivered a judgment regarding the binding precedent.
If you want to rely, you please.
No, and if your this is the preliminary point. I have taken this, but if your Lordship wishes to hear on merit of the matter, I have to make this argument. Kindly give this judgment 2025. Bikram Nath down, Justice Bagchi down. Is it in this? Is it in the? Yes. Our compilation. Take our compilation.
Yes, your compilation is here.
No, judgments, all judgments are not here. I'm sorry.
Again, judgment, such a big compilation, and
there are so many judgments. Just on the basic points, Miller. 2025 SSC on line SC 970, paragraph 17. Kindly see.
Paragraph 17?
Paragraph 17 of the 2025
Yes, SSC.
SSC online. Kindly let me read. Number of judgments are there, but I have just shown this. And latest day before yesterday, one judgment has been delivered by Justice Vikramath. Recently, it is argued that there are cases or counter cases and proceeding against parents-in-law have been quashed by the coordinated bench. Nothing the parents-in-law are septuagenarian, and there is no whisper in the FIR that they participated in the assault proceeding against them was quashed. Uncontroverted allegation the FIR charge sheet. He stated on the same footing, putting when the other in-laws, brother-in-law, sister-in-law against whom the proceeding was not quashed in criminal petition, though the order refusing to quash the proceeding against some of them in-laws was purposefully impugned order. It was incumbent of the judge, while quashing the proceeding against the respondent husband, to refer to the earlier decision of the coordinate bench and distinguish the reason therein to arrive at a different conclusion. Failure to do so infracts judicial propriety and discipline. Consistency in judicial outcomes is the hallmark of a responsible judiciary. An inconsistent decision coming out from different benches shake public trust and reduce litigation to a punter's game. It gives rise to various insidious sharp practice like forum shopping, spoiling the clear stream of justice. Impugn order suffers from the vice of judicial caprice and arbitrariness and is liable to be set aside and also on this score. And very written, my lord, there is the judgment of 2025 SSC on line Supreme Court 2366, paragraph 1 to 14, 1 to 4, the Kobe judgment delivery. This is 7 November judgment.
Paragraphs 1 to 4.
1 to 4.
Yes.
The judiciary draws its strength from discipline and not domination. The Constitution of India creates courts of record that are independent in their spheres and yet binds them together through a coherent hierarchy. The High Court in India possesses a wide jurisdiction, but the Supreme Court of India remains the final interpreter of law. Article 141 of the Constitution of India declares a law laid down by this court binds every court in the country. Further, Article 144 of the obliges all authorities, civil and judicial, to act in aid of the court. These are not ceremonial recitals. They are the structural guarantees that convert dispersed adjudication into a single system that speaks with one voice and commands public confidence. Appellate jurisdiction exists to correct errors and to settle the law so that like cases receive like outcome. When a superior court reverses, modifies, or renders, the court below must give full and faithful effect to that disposition. The authority to decide an appeal carries the authority to require compliance for without obedience. The hierarchy would become an empty form. Resistance or evasion does not merely deserve a party. Before the court, it erodes predictability, multiplies litigation, and weaker faith in the rules of law. The maximum interest replicate unseat finds litium, which literally means that it is the public interest that litigation should come to an end, reminds us that the society has an interest in achieving finality, and finality from the apex court in the guise that holds the nationwide system of justice. Judicial discipline is the ethic that turns hierarchy into harmony. It requires courtesy, restraint, and obedience to binding precedent, even where a judge is personally unpersuaded. The lawful course is to apply the precedent and, if needed, record reasons for inviting a larger bench to reconsider it. The unlawful and unjust course is to distinguish in name of while disregarding in substance or to recast issues in order to sidestep a rule that binds. Stare decisions are not movers, which means to stand by decision and not to disturb the settled matters, is not a slogan but a safeguard of equality before the law. Judges do not sit to settle scores. The gavel is an instrument of reason and not a weapon of reprisal. A vindictive stance is incompatible with the oath to uphold the Constitution and the law. Judges across our country must remember that collegiality is the companion virtue of the independence, and that a reversal on appeal is not a personal affront but the ordinary operation of a constitutional hierarchy that corrects error and settles law. Respect for the senior jurisdiction is not subservience. It is an acknowledgement that all courts pursue common enterprises is to do justice according to law. An appellate court reviews and, where necessary, sets rights the decision of the lower court with restrained and measured language. and the courts below reciprocate through prompt, recent, and transparent compliance. Court speaks through reasons and reasons that align with the binding authority, preserve both the legality and legitimacy of the judiciary. Article 144 of the Constitution makes obedience a custodial duty and not a matter of personal preference. A judgment that attempts to resist binding authority, undermine the unity of law, burden litigation which avoidable expense and delay, and invites the perception that outcomes depend on the identity of the judges. In a constitutional judiciary, it is the law as declared that brings the conversation to a close. We restate the simple duty of the courts, apply precedent as it stands, and give effect to the appellant's directions as they are framed. In that discipline lies the confidence of litigants and the credibility of the courts. This is a preliminary point which I have taken, that otherwise, if you lordship feel to go into decide the matter, then I will address on merit.
Take it on merits. What further? You've made 11.
Oh no, merit I have to make so many submissions.
What submission? Because all your submission is possibly recorded in the judgment of the Honorable Division Bench. It's a big detailed judgment with the precedents that you've relied upon.
Yes, that's correct. That's correct. But that's a
advance arguments on maintainability. Before my ladies, I'd like to supplement.
Yes,
Mr. Banerjee,
yes.
you mentioned
No, I have
maintainability.
I have been told by my juniors that the observation, reasonable classification, obited dicta, etc. That if your lordship wishes similar, I can address that also.
No, in that case, I have to hear the petitioners first.
Well, that's naturally. Otherwise, judgment which I have been telling you, my simple submission is this.
The matter is pending before the Honorable
Supreme Court.
Stay their hands for the time being.
Let us see.
Exactly the same line of Mr. Bandopadhyay, because I will not be repeating even with the same sentence. I am completely adopting it. Only I shall be saying two things. Thing number one, there is a 2025 judgment of the Honorable Supreme Court, which Snehal, 2025 SSC online SC 2325, paragraph 10. Justice Gava's judgment. This is exactly what Mr. Bandopadhyay has submitted, and I am also adopting it. So, just the language. Not in paragraph 10.
Yes.
We are deeply perturbed by the approach of Sage Sri Rahul as well as the High Court of Uttarakhand when the Sage Sri Rahul was continuously, kindly mark this word, because this whole thing started for a long time, continuously following the proceedings before this, that is Supreme Court, and was aware about the oral observations and the orders. If I can just have a little pause. Last night, I myself saw the entire video of what exactly was submissions on the part of the petitioners for the SLP. And I was completely convinced. All these were there. The Honorable Supreme Court had something specific in mind, which cannot be given to everyone. Like, what is the meaning of tainted? What is the meaning of untainted? What in the context of a list? All aspects. Why the freshers? They were not given relaxations. All were argument made and negated. Now, if I continue. And the orders passed by this court, nothing prevented him from intervening in these proceedings if he was of the view that any of the orders passed by this court or any of the observations made by this court prejudiced him. However, in the teeth of the sanction which was granted during the pendency of the proceedings before this court, approaching the High Court to challenge an order virtually amounts to this interference in the present proceedings. The High Court, no doubt, is a constitutional court and not inferior to this court. However, in the judicial matters, when this court is seized of the matter, this is the words, seized of the matter, it is expected of the High Court to keep the hands away. Well, that's the reason I said it's not that Lordship doesn't have power. There is something, we use the word propriety. When the Honorable Supreme Court is seized of the matter, it despite of the fact that Lordships Can, I'm not saying taking an extreme view, cannot at all, can, if lordship goes into that micro analysis of it. Most likely, if there are two options, both options being available, lordships might choose the options of not interfering because of the simple reason that the Honorable Supreme Court is in seized of the matter. So this is clearly on this. Now, just one more point, and I would not say anything. My lord, kindly, my lord, visualize a very fundamental thing. My lord, when a legislation or a rule is challenged, two things are different. One, what is challenged, and what are the bases of the challenge. What is challenged is a fixed rule. Basis can be X, Y, Z, etc. In the prayer in the writ petition, there was a specific challenge so far as this rule is concerned. It is possible that, my lord, there is always an innovative argument. Kindly visualize that once the rule which has in the prayer was challenged and it was not granted, rule was not declared to be ultra vires, and the matter ultimately went before the Honorable Division Bench and the Honorable Supreme Court, just because of one sentence, well, in fact, factually, that's an incorrect statement. That rule was not challenged before the division. That's not factually correct, because I have seen the prayer. In the prayer, specifically, rule was challenged. And that is also corroborated with Mr. Bandyopadhyay has referred that the Honorable Justice Saugata Bhattacharya also recorded regarding specific point of prior teaching experience. So all I say, it is possible that there can be a new XYZ.
Anyway, your submission is also to stay the hands.
Yes.
My lady, may I just address you? I've just capsulated all of this in a short note, 5 pages. My lady will have everything. And this is the compilation that goes with it. Please pass this on. This is the compilation that goes with it.
You are appearing for one of
I
the
appear
interveners.
in 4 cans. We prepared a list.
Interveners.
Yeah,
All right.
interveners. Can 4, can 1, and then in writ petition 24899, can 4 and can 1. So
All
4
right.
sets of interveners. We are obviously here also on that the merits have been argued, but simply on maintainability. I'll just take you to the first page. Now, my friend Mr. Banerjee has very eloquently argued this principle of stare decisis, which my lady is also bound by. And my lady, may I just start by saying this is my first physical appearance in my ladies' court. It's an honor to be here. Very happy to be here. Now, my lady, may please go to page 2 of my submissions. Just page 2. This is para 9. This is the petition where the Supreme Court has issued notice on. This is the petition where the Supreme Court. This is Avijat Sadhukan versus State of Bengal. Notice has been issued by the Supreme Court on 25/8/2025. Relevant grounds of challenge are at questions of law para, and we can look at those pages. And if you just see the pages of this, the compilation, we want to make this very simple and convenient, my lady. My lady may eventually agree or disagree, but we want to make it easy. So please see page 415 of the compilation that I've just submitted, page 415. This is the petition that was filed, the SLP that was filed in the Supreme Court, on which Justice Sanjay Kumar and Arvind Kumar issue notice. And this is the bench of the Supreme Court which has been seized of these matters pertaining to recruitment of assistant teachers. Now, please see page 415. My lady has the compilation. Paragraph 8.
Are you all aware of this?
Paragraph 8.
I don't want to waste the time of court.
Yes.
Can I just take you to this? Yeah, let me just finish.
Then get exhausted.
No, you tell me one thing. If the issue is pending there and you can raise all issues over there, let the court stay its hand for the
Yes,
time being.
yes, my lady. Yes.
No such issue of constitutional violence is pending. Let them
This
go
is
and
wrong.
sit down.
May I just finish?
What
Let me just...
SLP means? No, I don't have to teach anybody what
Yes,
SLP
yes. Yes, it's all
But
right.
the SLP not really arose from the fundamental order passed by the High Court. Where High Court says that the violence
Whether 2016 rule will apply or the 2025 rule will apply.
that is
This
different.
is the
That was-
challenge.
In my
The
petition,
virus of 10 marks. That is what is pending before the Supreme Court, amongst 12 other questions of law.
Yes.
here we have challenged the constitutionality of 2025 rule,
Yes.
That was challenged.
which was never before the court. The division bench was very categorical saying the rules are not challenged. the division bench interpreted on the strength of the rules being valid. Now I am more on fundamental. I know they are scared of going
on
into
the
issue.
strength of the rule being valid means the 2025 rules is valid.
Yes, this is the issue now. I am urging, I am an independent petitioner. That council might be saying, but council.
No, I understand. But if the issue is decided, then there is no point in deciding
it is pending.
it all over again. It cannot be done.
Issue, Milord, is not pending. The Supreme Court, with deepest of respect of my little experience, will not go beyond the fundamental order passed by the court. Therefore, here, raising the issue is really simply trying to avoid the court, nothing else.
My lords, my lady may please see page 414. These are the questions of law that are pending before the Supreme Court. Please see that the Calcutta High Court has failed to consider the entire recruitment rule of 2016, and therefore the second state level selection test 2025 is completely changed. This is page 415. Please see the bottom of page 415. Question 8. Whether the Honorable Division Bench of the Honorable High Court of
read
Calcutta,
out just now, Mr.
yes,
Bhatt,
has
read
failed
out
to.
this.
This is the petition that is pending at the Supreme Court, which the Supreme Court has issued notice on. So when the apex court is seized of the matter, including any and all questions that are being raised by my friends through a backdoor entry in violation of stare decisis, judicial discipline, and hierarchy of courts,
What is this?
I don't know what this is. Please stop all this. Please stop all this.
1 minute.
Please.
Who are not the advocates will please leave the courtroom because the entire proceeding is live streamed and anybody can see. Please leave the courtroom.
Yes.
Now, may I keep reading, my lady?
Please leave the courtroom. This is not this way how the Calcutta High Court functions. Apart from advocates, please leave the courtroom. What is happening? Right, will please leave. Whoever's clients are there, please leave.
May I keep reading, my lady? Whether the Honorable Division Bench of the Honorable High Court, bottom of page 415,
yes.
has failed to consider that in Gazetted Notification Schedule 2, 10 marks will be given for prior. Yes, now may please see 15, 418. Can I finish, Mr. Bhattacharjee? Is this the way we argue? Let me finish my arguments, then you please. Now please see 418.
What you want to show?
That this is a calibrated attempt to disturb the functioning of this court. But I am not, this is the Facebook posting by one of the aspirants who want to get 10 marks, not being qualified for this purpose. They are posted. কাল সকালে কোর্ট চত্বরে সকাল সকাল যেন ভিড় করে থাকে। I am not mentioning the name of the judge. ঢোকার সময় যেন দেখতে পাই ডাল মে কালা হয়।
No, this is
বলবে আমাদের কেস আছে সেই জন্য এসেছি চাকরিহারা শিক্ষক শিক্ষিকা।
Please leave. The doors are quite wide. You all can leave out.
How, Mr. Bhattacharya, if you place this, we can place so many of your junior statements.
This is not the way it's done. This is not the way it's done.
Whatever they will be placing. But this copy has not been done despite your lordship's direction. But they had agreed that they will
Affidavits of service are complete.
Any document.
Soon and if they cannot go out, then the court has to stop.
Advocate, nobody is allowed to enter. These matters.
Since the proceedings are live streamed, everybody can see it. What is the use of long court? It's absolutely no use. And if they think that they're going to put pressure on the court, I'm sure the bar is there to save the bench.
No. What I am submitting from the next day, whenever these types of matter, no.
Yes,
Nobody,
outsiders.
no litigants. My lady, may I keep reading? Page 418, ground
Yes.
15. Ground 15 of the petition filed in the Supreme Court.
Right. So the-
Whether the Honorable Division Bench of the Honorable High Court at Calcutta has failed to consider that this Rule 2025 is a perfect legitimate means for arbitrary whimsical action of the authorities. The authority cannot create any special class of people to give extra benefits by way of experience marks. This rule has not a hint of reasonableness. This is the ground. The protection provided under 14 of the Indian Constitution is also denied by this notification dated
Yes, this
29.
also have been read.
This is exactly what is challenged before my lady. Now please see, my lady. Please
1 minute.
vote-
You are reading from Abhijit Sadhuka, isn't it?
Yes, my lady.
Are the petitioners aware Abhijit Sadhuka's petition? Please take down note.
But they are aware about Orunima Pal.
Orunima Pal.
Orunima Pal as well, my lord, is there.
Abhijit Sadhuka.
No, my lord, we have, my lord, Abhijit Sadhukan's copy was served on last Saturday
No,
to Mr. Sami.
they do not know. They are not party.
May not be.
We've given a copy of everything. All the arguments, judgments, rules, everything.
Mr. Samir, Mr. Dasgupta.
Malad,
But
Abhijit
your-
Sadhukan's SLP, Malad,
This is what is read. Not received.
Mr.
Get a copy.
Mr. Bandopadaya's copy and
They are all Orunima Pal. If we are aware of Orunima Pal, my lord, I show that every point was taken.
All right.
Yes. Now, may I just take you to page 431, which is the Supreme
Right now, it is Abhijit Sadhuka's SLP grounds
Yes.
that are being placed.
Page 431, Supreme Court issuing notice on this petition, the grounds which I read.
All right. All right.
Please see, it's a detailed order. Justice Sanjay Kumar issues notice. It's a detailed order. Now, please see. Can I just take you back to my note, page 3, again on maintainability.
1 minute, 432.
431, my lady. It starts
Yes. The
25
next
A.
page, yes, next
Yes.
page. I see notice have been issued.
And tagged with SLP diary number
Right.
titled Bibek Paria.
And the court directed that in the meanwhile, all selected and appointed untainted candidates,
Yes.
selected and appointed,
Yes.
who were permitted to continue shall be allowed to participate in the fresh selection
Yes.
without insisting upon complying with 50%.
Yes, my lady. Because the Supreme Court had, on this 50% criterion, had
interfered.
protected it because
Right.
of the nature of this recruitment process. And you'll see at the bottom of that same para, classes 9 to 10, classes 11 to 12, rules 2025. It is exactly what is pending before my lady.
All right.
Exactly. Now, please see. May I just take you to page 3 of my submission notes on maintainability again. Page 3. We have now, Mr. Banerjee has now gone through stare decisis. We have now shown to my lady that exactly the same questions, the same issues are pending before the Supreme Court where notice has been issued. Now, the third point, the law on this, the law, why this is not maintainable in law as well. Top of page 3. Qualifications for appointment. My lady has this, top of page 3.
Yes.
Qualifications for appointment to a post are within the exclusive discretion of the employer. So these 2025 rules, my lady, now the Supreme Court has settled the law in Maharashtra public servants. Now, prior experience, please see middle of this page. Prior experience marks in teaching, middle of the page of same page 3, were upheld by the Supreme Court in Allahabad University versus Gitanjali Tiwari. This is what I told my lady virtually when I was appearing, paragraph 16. The practice of according marks for prior experience in a recruitment process is not unique to this recruitment process.
All right. Yes.
UGC regulations, my lady, this is all India regulations on minimum qualifications, has exactly the same rule.
All right.
You will find exactly this rule in many states vis-a-vis recruitment of teaching, and they are all sustained on the basis of these two cases of the Supreme Court. That the employer, in this case the state, gets to decide within its executive and legislative discretion that we require this prior expertise. A class 9 student would benefit greatly by having a teacher who's got 2-3 years experience as opposed to having a fresher. Now, please see page 4. I prepared this note just so that I won't take much time of my ladies. Please see page 4.
Only one thing. His lordship feels that Lordship is not going to interfere. It may not be proper to say anything on merits. That I feel.
No, nothing on merits.
No, no, nothing on merits.
Right
Nothing on
now,
merits.
I'm thinking of whether to entertain.
Yes,
or not to
maintainability.
entertain.
Maintainability.
We won't be able to.
No, no, no.
Yes. No, no, this is on.
Not on merits. Not on
My
merits.
friend, may let me argue. I didn't interrupt you.
Merits.
So please see paragraph 14, page 3. Just on maintainability, paragraph 14, page 3 of my submission note.
Yes.
Please see what the Supreme Court says on qualifications. What is before my lady is the ability of an employer, the state, to prescribe qualifications. Can a court traverse that? Please see what the Supreme Court says. Maharashtra Public
Not
Service.
on merits, please. Not on
No,
merits.
no, my lady, this is not on merits. This is on the principle of law. Employer may prescribe
Right
additional
now-
or describe.
Right now, what is going through the mind of the court is whether to hear y'all at this stage or should I wait till the 24th or the 26th?
Please wait, my lady, while the Supreme Court is seized
What
of this.
is,
Yes.
going through the mind of the court?
Yes, and this is a bench of the Supreme Court because I've argued it from day one before Justice Sanjeev Khanna. This is a bench of the Supreme Court that has been seized of this matter from when Chief Justice Sanjeev Khanna first set aside the recruitment. Now Justice Kumar is hearing all these petitions from Calcutta on recruitment
All right.
specifically.
Mr. Bhattacharya.
May I just hand over the note that you
Again, note.
that small note your lordship wants on the argument?
One has come. This is the second one.
I have not.
Please don't. Yes, the slimmest.
No, I have not given note. I have given the documents and the judge.
This one
I
is
have
also
given
the
a document
document.
note, my
Not
lady.
note.
See the number of candidates involved. For this, the documents are so.
I have set out the press
Give me the
that
copy.
we made.
Two
Give us a
copies.
copy.
Two copies.
You don't allow.
Two copies have come.
My lady, we'll take
Give
one
the
copy.
copy
my
first,
lady.
then I will
We'll
come.
share my lady's copies.
You can't wait with me.
You are also for one of the interveners.
Yes, sir. In can number 5 and item number.
Whatever.
You're supporting us. Okay, then I thought it that you are Mr.
Couldn't understand whether supporting or opposing.
Please support. My lord, those supporting are genuinely more jovial, my lady. We are optimistic. Those opposing are not so.
I have set out the prayers made below in each and every new petition which has been disposed of. And your lordship will find in only Mapas, there was a specific prayer challenging the rules. My lord.
No, no.
I don't have to, I have authorities that in a separate petition below, a petitioner can challenge even the order passed in a similar petition by the other court. Kindly takes up below what is the foundation, order of Honorable Justice Shomen Sen in Math 1017. All SLPs arose from this. Well, let us go to the basics.
Will it be very difficult, Mr. Bhattacharya, if when the matter is taken up by the court on the 24th or the 26th, the Supreme Court, you'll get an order, one-line order that this can be urged before this bench? The court will be open to hear it.
Lord,
Why transgress?
I am not before the Supreme Court. I am a petitioner.
Independent.
No, not this
Because
party.
it's
That is different. That is different. I understand.
Counsel,
No, as a council, it's all right.
I have argued on the same
Yes,
different
yes.
positions. Well,
Right.
let
It's
them
not that.
confuse it.
It is not that.
Petitioner before
But
the-
there are many who are parties over there. If one line order can be obtained from the Supreme Court that this individual challenge to the rule can be entertained by the High Court, the court is open to it. This will settle issues.
May I answer? Lord, you kindly excuse my impertinence.
No, it's all right.
But the question is, the Supreme Court will mock at me that having not gone through the order appealed from, what is the order? I just placed the order. Kindly takes up the division.
The order has been placed.
No, they have not.
You
placed it in the
have-
issue. But I am sure the order has not been placed in the context. Kindly come to me, Lord. The kindly takes up the judgment of the division bench. The present appeal, paragraph 2. We have seen in the country, how the tainted peoples always must take advantage of the situation. And the law is well settled, they cannot be allowed to participate and get the marks. The present appeal, I am talking everything on authority. I am not talking on my own wit.
Compilation page number 371.
The present appeal, paragraph 2.
Page number 371 of Abhijit Sadhaka. 371. Page number 3.
Division bench judge.
Orunima 371. Page number 371.
This appeal, the just honorable division is considering the present appeal is directed against a portion of the impugned order whereby the contention of the appellant that the recruitment process initiated in 2025 on the basis of the said rules of 2025 could not be made applicable to the present appellants as they are to be considered under the recruitment rules of 2016 was rejected by these orders.
What I could understand from the order of the Honorable Division Bench is that the broad question was considered by the court whether 2016 rules will follow or the 2025 rules.
Right.
Nothing individual. This is what
This was
I could understand.
And you have correctly
Right.
understood that is the scope of the division
Right.
judgment.
Now, at the time of deciding this, the court has gone into the finer points, whether 50% is proper, whether 10 marks is proper, and whether the authority can fix up the eligibility criteria and all these things, and the court has passed order. But I have seen the issue before the court was something different. This is what
Absolutely.
this is what came to me.
And court
Right.
really said that these issues are left with the executives. Court cannot interfere.
Right.
Now, my
Now-
point is here that these rules will not violate the constitutional provision. If I can satisfy, otherwise, I am out.
Right. So I will prefer waiting till the 24th or the 26th rather. Let us see what happens because the issue is pending. Whatever order will be passed by this court will always abide by. The steps taken by the authority will abide. That is the interim order in one of the matters.
My lord would be pleased to then record that while the matter has been considered for constitutional validity, the point is taken that these constitutional validity is being considered by the
Yes,
Supreme
yes, I'll record that in the
Court.
order.
On that ground.
Yes, yes. On that ground only.
This is one point. But another petitioners I am representing, where we not taking the rules 2025 as it is, even then at what stage the
10 marks can be awarded. I'll come to that later on. Let me record it.
Item number 14.
That is separate. That is separate. No, I'm not saying. This is whatever.
No.
that was
Whatever. See, a client, when a litigant comes before the court, the litigant prays for the moon. But the court doesn't consider that.
the
The
court
court
says the
fixed-
recruitment rules of 2025
I
has
see.
not
I
been
have-
challenged.
Right. So I'll please come. Please come.
Serial number 14, my lord. This is issued completely different because 9, 10, my lord, the untainted teacher is eligible to get marks for the 11, 12.
3. This is item 3.
Yes.
This is item 3. Just wait.
Sir, interview published subject matter of outcome of this petition. Subject matter of outcome. 3, 4 আমাদের আইটেম নাম্বার গুলো বলো।
সেদিন আমি চাকরি দরকার
5,000 লোককে চাকরি দিয়েছি।
The issue as to whether 10 marks can be allocated for prior teaching experience in the
open selection, direct recruitment.
2025 rules. লিখে নিন তো West Bengal School Service Commission selection for appointment to the post of assistant teachers for upper primary level of classes except work education and physical education. Classes 9 and 10 and classes 11 and 12, rules 2025 are impugned herein. Stop paragraph. Learned counsels representing the commission, the interveners, and the state respondents submits that the said issue is pending consideration before the Honorable Supreme Court, and the matters are due to be taken up for consideration by the Honorable Court on the 24th and 26th of November 2025. Stop. Next. Though the aforesaid submission of the respondents has been opposed by the learned counsel representing the writ petitioner, but as several grounds of the special leave petition have been placed before this court, this court is not inclined to adjudicate the issue at this stage. Stop. Hearing of the writ petition stands adjourned till 28th November 2025. Stop. Parties are directed to produce the updated orders of the Supreme Court on the adjourned date. Arecta jinish. Compilation filed by the West Bengal Central State Service Commission, School Service Commission, the interveners in court today be written with the records.
One thing that has probably gone down, that the court was invited to decide the constitutional violations of the 25 rules. That is not pending with the Supreme Court.
That we would also record this rule was challenged before the
that record from the order.
Is there in the order. Why record all these things? যেখানে বললাম না, it is not challenged. যেখানে বললাম opposes the submission, ওখানে লিখবেন the constitutional validity of the 2025 rules have not been challenged.
Yes. Now the parties may get a clarification so that this will.
I am not mentioning. If you can get it done, fine.
Very well.
This is, you have said.
No.
This is item 3.
In the SLP, how can a varies be challenged?
This is item number 3.
My lord, item number
Item
3, 4, 11, 12, and 13 are similar.
3,
4,
4,
11, 12, and 13.
11, 12, and 13. Same order will go down. Let the petitioners come. No, let the petitioners come. Item 5. Is it the same thing? It is something different. Totally different. All right, please wait. Please wait. Item number 6 is also different.
Private school teacher challenge করেছে
Wait. I'll take it up.
রাখতে দেবে না ইন্টারভিউ ইয়ে হবে
Item 7.
My lord, may I indicate one thing, my lord? Because of that matter, I challenge the 10 marks and if is given to the government school teacher, the same, my lord, benefit ought to given to the others teacher also.
Which one?
That is not in the list, my lord, already filed, my lord. I supply the number, my lord.
Yes.
Otherwise, my lord, the list will publish, my lord, within 1 week, my lord. Matter will become infectious, my lord. It will be kind enough, my lord. Kept any day, my lord, my junior will supply the
Item 7.
Item 7 and 8. The issue is whether central government school will get the 10 marks, my lord. 14th, your lordship has been.
14th.
7 and 8.
But then objection, yes. The commission doesn't have any objection. Yes, against sanction post.
So that I will satisfy your lordship.
But the 14th. 7 and 8 on the 14th. 7 and 8 on the 14th. Item 9.
My lord, 9 is.
Certain additional point in 10. 9, Mr. Dasgupta was arguing in the last.
All right. देखिए 9 टा एकटू देखिए There are many oppositions.
এটা তোমার নাই হ্যাঁ হ্যাঁ এখানে দুটো পয়েন্ট কখন দিতে পারবে পাবে না টেকিং দ্য রুল টু বি
That is also there, my lord. It's not appearing in the list. I'll number.
It is there in a pool. Now it has become a pool.
Now it is there in the pool. And on the point of contractual, my lord.
Yes, Shishir Dash, item 9.
Made with your lordship.
Retreat. Puro, entire file. This is regarding the stage as to when the marks is to be added.
The interpretation of rules.
But then will we go into this? Let the court decide, Supreme Court, as to whether the 10 marks will be allotted or not. If it is not allotted or allotted, then...
But no, the problem is, Milord, in the meantime, what they are trying to do, they will, Milord, get these, Milord, the favored students again selected, and publish the result, making and shouting that this has become infructuous. Therefore, there are two prongs of attacks. One is constitutionality, it remains. Milord, even after 10 years, it can be declared otherwise.
Yes.
But here, Milord, assuming that the rules are valid, what should be the interpretation?
What should be the stage? Yes.
Kindly come to Milord. It's not about success.
No, successful or not is different.
But I am a Milord fresh candidate. 14,000 on this 100. 22,000 Why should
no,
I
if 22,000 is there,
yes,
then why this 10 marks? When will you add? When will you add? When will you add? Before the interview. Before the interview.
That cannot be done.
It has to be done prior to the declaration of the final merit list.
And second question would come whether, Milord, these after the Supreme Court judgment, Milord, whether they can be treated as, Milord, qualified teacher.
Qualified teacher.
Because they have the benefit of trying to get the benefit of experience.
Yes.
And after the appointments having declared void, whether they can be said to be qualified teachers.
That means the 10 marks issue comes in. Right.
10
marks.
One is, Milord, 10 marks cannot at all be allotted, irrespective of who is there. Here, Milord, if I take the rules does not permit the tainted in the sense as the Supreme Court said, whose appointments are declared void by the court. I have a similar judgment in other cases also. Therefore, we are sticking to the interpretation of the rules. And I'm inviting my Lord to deal with this.
No, what will be the, what answer do you want? That the 10 marks can be given to the past, for the past teaching experience or the stage?
So, two issues are here. First of all, if at all 10 marks can be given, then
at what stage?
At what stage?
Right.
Second, Milord, the 10 marks can be given, Milord, to the teachers having the experience, past experience.
Whether the candidates who participated in the earlier recruitment process will get
be taken as
eligible.
Past experience. That's the point. But kindly come to the rules statement. Milord,
This is what his submission is.
No, I don't say I could be allotted, but not to the teachers who have no experience in the eye of law. Yes. Well, let me, whole difficulty, Milord, I am gagged. Let me speak out.
Let this hearing be done one by one.
Let us start. Milord, No, no, no. Mullah, let me please it. I will be happy to be wrong.
Wait.
I don't claim that I am always right, but let me speak out. Mullah, kindly come to the rules at page 26. Kindly come to 2K. Interview list. In respect of the state level selection test, means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score. Therefore, the determining factor is preliminary merit score. And what is preliminary merit score? That is score from written test and TET and academic score in the ratio of so and so. Therefore, at this stage of preliminary merit ranking, only thing could be taken note of is the academic score and the TET, nothing else. What the written test, academic score, written test, academic score, and TET. There's no doubt about it. Then merit list. Merit list is a subsequent stage. In respect of the SLST, means in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean in addition to what has been stated in Rule 21K, marks obtained in oral interview, lecture demonstration, and prior teaching. Therefore, the prior teaching, lecture demonstration, oral interview comes while preparing final merit list. After the interview is over. If this is the rule, which is very categorically clear, the question of 10 marks, which is prior teaching experience, will come at the stage of preparation of the final merit list, not at the stage of preparation of preliminary merit list. And kindly now turn to the schedule at page 36. Schedule 1 is the academic qualification, including professional qualifications. My lord, will find what is meant by academic qualification, educational qualification. This is for 9, 10, and B for 11, 12, the same thing. Therefore, the academic qualification is defined in Schedule 1. Now kindly turn to Schedule 2. This is selection to the post of assistant teacher. Now, 9, 10 shall be made on the basis of marks obtained in written examination, educational qualification, and prior teaching experience, oral interview, and lecture demonstration, which in fact resonate with the definition of merit list. There the academics, educational qualification 10 marks, percentage wise. This is really, Millard, a level playing field. Now the latest judgment of the Supreme Court, I say, delivered by Justice Dipankar Datta on recruitment, says the level playing field is the sole consideration to comply Article 14-16. Then the prior teaching experience. The prior teaching experience you wanted to bring under educational qualification, which really contradicts Schedule 1 and also contradicts your main rule. The schedule of a rule cannot go contrary to the main part of the rule. And if you follow this interview list and merit list, then there is no doubt that so-called addition of 10 marks can be offered only at this stage of merit fixation, not at this stage of preliminary screening of interview. Why this is being done? Then I have to go to as I say, this is a malice in law. You are trying to do it because 2016 rules doesn't provide these things. This you are trying to do only to accommodate the persons who have been found to be illegally appointed because of entire corrupt practice. And now again, everybody will say, how do you say this? Kindly come to the judgment of the division bench I am not referring to. Kindly come to the judgment of the Honorable Supreme Court and subsequent clarification by the Supreme Court itself. That page 130, the delay and latches goes, then kindly come to conclusion, page 131. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who were appointed must be terminated.
I will request you not to place this now. Let us only decide this issue. At what stage the 10 marks will be given? Interview list or the merit list? Only this. And the other issue that you are raising, whether they will at all be entitled to the 10 marks or not, that I'll keep it open for the time being.
Very well.
Only this portion, the stage.
Well, I will not concede to the observation of court.
Yes, because this will be to some extent touching the other issue that is there before the Supreme Court. Let us see how things proceed.
Now, therefore, so far the at what stage 10 marks can be allotted, Milord?
Yes, I get it. No, there are some other petitioners. You'll answer in the same go. Academics, you said on the last occasion there is an S which includes a plural. Here it cannot be done.
This one thing.
One.
And second thing I argued, which has not gone down to the order, Milord, that interview list my senior has already placed the definition. Merit list definition. Last occasion I had shown to Lordship that this is these marks to be calculated at the time of preparation of merit list is in addition to the marks given in 2K, 1K. Therefore, these marks, total marks is 100. If they give teaching experience at the interview list level, then the total marks would be 110. Because 2K...
Twice you added.
It must be. Otherwise, they are saying, according to the commission, these 10 marks would be given at interview level. Now, kindly
according
read,
to the commission, the preliminary merit list will contain the 10 marks.
No,
because
kindly
that is
read,
in the academics.
Kindly read this in this way, Milad. Means, merit list means, in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean, in addition to what has been stated in 2K. Therefore, if they give 10 marks of teaching experience in 2K level, then
cannot give it in L.
Then it states marks obtained in oral interview, lecture demonstration, and teaching experience. Therefore, teaching experience they are in any event giving at the time of merit list, in addition to what is there in 2K. Therefore, this teaching experience cannot be given twice. That's my point. And last question I've submitted that if this 10 marks is given, this rather teaching experience of secondary level is made applicable for senior secondary, then there will be nobody from the freshers who will get chance.
That on the next day. That on the next day.
But this is again on not on validity.
No.
That you will show the record.
It will to some extent touch the validity issue because here the those who were there, whether they'll be entitled to get that or not, will be an issue.
16 candidates.
Yes.
As the leadership pleases. I have prepared a supplementary affidavit, Milad, to bring on record. Sarkaraj, order of Supreme Court, Milad. Though you will
Sit.
Only at order of Supreme Court actually next.
Order of the Supreme Court?
Yes.
Which order?
This is again touching to the page 10, only for the purpose of page 10, second paragraph.
17th April.
Page 10, second paragraph.
Yes.
page 10, second paragraph. Only for this. Only for this. Oh, that's all.
Freshers. They are also freshers.
May I?
Sir, I have heard you on the last occasion.
No, no,
Nothing
but
more.
after you have to hear me on this.
Yes, yes.
That's I'll at the end I should submit. Let them submit.
No, no, I have heard your submission.
No, not hard on me on this. Now new argument has been made.
No, not a single new point has been raised today. All old ones. Same point.
No, but they have want to hear, do not hear, that's the matter.
Yes, yes, please. Yes.
Kullan, just a second. Suppose I missed you. In support of my submission, I just rely upon one judgment. Mr. Banerjee will definitely deal with that. 2011 7 SCC. 2011 7 SCC. Page 789.
Is it there in the compilation that has been filed today?
Yes.
Agekar compilation ta dekhiye ekটু. Spiral binding.
Page 789.
Spiral binding. What is there in the judgment?
That the schedule of a rule must be in consonance with the rules and statutes.
Well, now that's a separate spiral binding. Give me the citation so that I can take note.
Citation does the Joshua compilation.
1K.
Taken in 2011 7 SCC page 789.
রাখুন রাখুন রাখুন
আমাকে শুনতে
শুনে
চাই
নিয়েছি, আপনার কথা শুনে নিয়েছি আর নতুন শুনবে কি?
ভুল ভাল শুনেছি আমি তো
সেই জন্য শুনবে না, দেখবি এই সব
Called on merit for oral interview and etc. Category wise, on the basis of preliminary score that is scored from the and on state for transfer, it is ratio of transfer 1.5. Preliminary later give the academic and academic. Then the academic score is within the statute. The differences between tests, then state for upper primary and academic. So what is an academic? That has been said, madam, to academic
Page
এটাই তো দেখা
36. Yes, the schedule. Schedule.
One is educational qualification trademark. Then no rounding up for prior teaching experience. Then
এই তো দেখেছি দেখে আছে আমার এইটাই তো এইটাই করতে জানি ওটা তো
another heading academic. Then come back again, my lord. Again to the last point, then preliminary merit score, written test, gate, and academic score. This is for the part of the interview. Who interviewed this will say who will be interviewed, list of that. Now let's kind of come to L. Merit list in respect of the SLST means in case of both a list of candidates prepared category wise on the basis of merit. It shall be in addition to what has been stated in 1K. Marks obtained in oral interview, lecture given and prior teaching assistance and track include all the achievements.
So does it mean the submission is that you will add the prior teaching experience twice?
No.
This is what is mean.
That is a harmonious construction.
Right. You are the commission.
I am not a rule maker. I am the commission.
You are the commission, right? Whether this 10 mark is given at the time of interview or at the time of final merit list, it doesn't bother either the state or the commission.
No, but we are working on that now.
You are working,
I have
right?
made the submission.
Yes,
I have implemented the rule.
yes.
I have to implement the rule.
Mm.
Now, this is practically, this is not correct. That academic, but it has been more specified. It has been oral interview, lecture, kindly see. Why is it? See, whether academic score in score transfer and merit list means in case of post, in case of kind of on the basis of merit, so means in addition to what has been stated in Rule 8, mark obtained in oral interview.
What does this mean? That means there is a separate mark in 2K, and then with what you get in 2K, you add up oral interview, lecture demonstration, prior teaching experience. This is what is mentioned in the... No, but this is what the state government rule says.
Now your losses kindly come. Let's say make an harmonious construction.
Let us make an harmonious construction, and whatever is there in the rule itself. Why will you jump steps? The L, let us read L. Merit list, please read once again.
Merit list in respect of the SLST state selection case. In the case of post, a list of candidates prepared category. Why on the basis of merit? We shall mean, and we shall mean, in addition to what has been stated in the rule, the marks obtained in
Right. So 2K, there is a mark fixed, allotted. With that, you add up oral interview, lecture demonstration, prior teaching experience.
prior teaching experience already has been taken.
Then why will it be repeated twice?
Repeated, this is a redundant one.
Ah.
There is a redundant.
Oh,
No. Not be given. Now the kind speak.
Don't have that technical.
Yes.
Definition.
Advocate General state. 11A. See, the Central Commission. Central Commission an eligible category on the basis of the preliminary merit score as defined in 2K in the ratio of 1.6 of final result.
There is nothing mentioned about the prior experience in this 8 that you read out.
No, not here, but I say that 2K and 11 Romani. While interpreting 2K and 8, Malad, this course cannot ignore 11 8.
No question of ignoring. Yes. All right.
Everybody, now we are kindly, this is the judgment.
এটা বলছো তাহলে কেন আর কি আছে শুনতে চাইছে না ঝামেলা করবো
Yes.
2002 SSC, 2002 volume 2 SSC, T1E. Kindly come to paragraph 11.
What is there, please say?
The interpretation to section 3 as noticed there offered by the High Court cannot be possible by adopting neither the statutes can be read in the manner and fashion available to done by the High Court. Appointment of the competent authority in terms of the right now purpose of the act indicate the authority is administrative and neither judicial authority. The statutes shall have to be considered in its entire and picking up of one word and from one particular provision, thereby analyzing in a manner contrary statement of objection is neither permissible nor warranted. There are certain fixed canons of construction and interpretation of statutes and the High Court finding as regards the office of the competent authority influence. But this is a principle. Now another one judgment. But then my submission would be that to this limit, that it has to be read, it will be done, it will be on the basis when the intent list will be prepared.
All right. Yes. Yes.
When we interpret a rule, the first thing we find out that there is no challenge to it. First, if there is a challenge to the rule, then the parameters are completely different. Whether it exceeds the legislative power.
Please do not make this submission. That is not the issue.
Now, today, my lord, your lordship is invited to look into or adjudicate as to at what stage the marks for prior teaching experience are to be given. Number one is prior teaching experience. You need to look into the object of inserting a prior teaching experience as one of the qualifications. And where a rule also permits people who do not have the prior teaching experience to participate or offer their candidature process, obviously they are in a separate component. So prior, it's not like the promotional rules from post A to post B. You must have say prior teaching experience of say 5 years. Which applies to all the candidates.
Merit comes seniority, seniority comes merit.
Now, here is a case where your lordship would find two categories of person offering their candidature in the same process. And prior teaching experience fetches a few more marks to the persons who have the prior. The purpose is, what would be the purpose? Because your lordship is dealing with the rule, Millard emphasizes, Millard effectuates the broader aspect that is Article 21A of the Constitution. Because this rule is confined to the upper primary level of classes, that is classes 5 to 8. Millard Article 21 fundamental. Therefore, these rules what we.
Sir, why don't you sit? Please give
But
him
there's
a
no
chair.
place to sit. But I can sit on the lap of it.
He doesn't want to sit.
No, no.
He says, I'm
Sir,
a
please
permanent
sit.
standing counsellor.
Please give him a seat.
Seat is
No, no, please. Sir, it will be very improper if you stand. Please sit.
Yes.
Please sit.
আমার বিকাশে কোলে বসতে হতো আমার।
Now, my lord, the dominant aspect or the broader aspect or the more important aspect, my lord, is what, my lord, we all lose sight of. Is this rule framed only for the purpose of selection, or it has a larger aspect in it, embedded in it, which is to offer or effectuate the fundamental rights of children between 6 to 14. And Article 21 and the follow-up legislation, that is the Right to Education Act, Millard provides that quality education has to be provided to those children of that age group. Now, please keep, Millard, these two aspects in mind, Millard, for the purpose of interpreting the juncture at which, Millard, this prior teaching experience marks are to be awarded. First is, what is the purpose of inserting this kind of a clause? The purpose can be nothing else than to, Millard, provide or ensure that better quality candidates are selected. Now, how do you distinguish? Broadly, inter-se merit is something different. But broadly, we distinguish between, for example, take a Millard hypothetical case, not related to this matter. But in a case where, Millard, say one group high secondary candidates, past candidates apply, and another group, Millard, secondary candidates apply. There, Millard, logically, Millard, if somebody says that no, I will consider the
higher secondary examinees or past candidates as better or in a higher pedestal than the secondary candidates. But that, in my very respectful submission, is a logical approach. But merit-wise, maybe the secondary candidates may outshine the higher secondary past candidates. So therefore, the purpose of providing this clause is to ensure that more experienced persons or persons who have teaching experiences are put in a better place for the purpose of selection. Why? Why is this incorporation? To ensure that better teachers are tried to be made available. Finally, who's good, who's bad is again something a matter of perception, performance, many other unknown things. So this being the purpose, now Millard kindly read the rules. But we cannot read this rule only to confine it to selection or confine it between the inter-se merits between the prior and persons having teaching experience and persons not having teaching experience. Now please take Millard 2K, I'm sorry. But your lordship must have read this rule many times. Now, interview list means etc. in the post of so and so, a list of candidates to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score. So when I call people, I first prepare a preliminary merit score. Now I have to distinguish. Here, Millard, I should be the School Service Commission, be that as it may. So I have to distinguish between the more experienced, I call it the teaching experienced people, and the others who do not have the teaching experience. Therefore, Millard, at the preliminary score assessment stage, I have to take into consideration the merits of those persons, or I have to take into account those persons who have the prior teaching experience. Now, why I say this? Because what is the purpose? You have to look into the purpose also, because
no, you are going around the same thing all over again.
Yes.
What is the stage? 10 marks, we take it that yes, you can give, because right now we are taking it to 2025 rules as a whole, assuming that it is all right. Challenges before the Supreme Court. This is not the issue here. The court is not deciding. At what stage will this 10 mark come?
Preliminary merit score.
Yes. Where from are you getting that the 10 has to be added earlier and not later?
Please take rule number 6.
Rule number 6.
Yes. Your lordship must have been taken through Millard these.
No, 6.
Yes, I'll come to the schedule. I'll come to the schedule.
No, it's all right. Schedule rule number 6.
Rule number 6 says manner of selection. Selection shall be made category wise on the basis of merit in the manner as specified in Part A of Schedule 2. Now let us come to Part A of Schedule 2.
Yes.
Which is page 89.
Yes.
Millard, Schedule 2 Part A has, Millard, 4 parts. All these, Millard, the first part is written examination, which is based on OMR sheet marks. Then 2 is academics. Now this academics, Millard, has been divided into 2 parts. That is educational qualification 10 marks and prior teaching experience 10 marks. Those who are not having prior teaching experience, for them B doesn't apply. Then is the oral interview and then the lecture demonstration. Now, Millard, based on this, Millard, prior teaching experience is part of the educational qualification which is provided under the rules. Therefore, prior teaching experience marks is part of the academic marks that a person is to have.
How do you say that it is provided within the group broadhead academics?
Yes, Millard, 1 is written examination.
Yes.
2 is academics. Now, what is academic? Academic has 2 parts. These two parts are applicable in respect of two categories of person. If a person has prior teaching experience, then into A and B applies.
Submission has been made to this extent
Yes.
that the word here in Schedule 2 is academics. It's S. It's
Yes.
S,
Yes.
plural.
Yes.
In K,
Yes.
it is mentioned only academic. The
Yes.
S is not there. And this S
Yes.
considers the teaching experience, which is there in the schedule. It is not there in K.
Yes.
So,
But are they are
stage.
my learned friends suggesting that this is plural and the other is singular?
Right. It
Millard,
is.
Millard, general clauses act, Millard. Singular includes plural, plural
Very well.
includes singular.
If that is to be
Yes.
taken, if that is to be taken, then K and L will be contradictory.
I'll come to that. I'll come to
Yes,
I'll
please.
come to that. Therefore, let us Millard, first clear the air that in academics, is academics only confined to educational qualification, or academics will also include prior teaching experience for
Right.
those who have the experience?
Yes.
Well, my very respectful submission is, unless Millard Schedule 2 is challenged on XYZ grounds, Millard, the Schedule 2 as it is to be read, which means that prior candidates having prior teaching experience has twofold academic qualification, if I may put it broadly, and candidates without teaching experience have only one part of the experience under academics.
All right.
Now, kindly come back to Millard, Rule 2K.
Yes.
But I don't think, Millard, academic and academics would make much of a difference. One single alphabet will.
রাহুল বলছে যে এখানে আগে অ্যাডজেক্টিভ ইউজ করেছে আর ওখানে আগে নাউন ইউজ করেছে এখানে অ্যাডজেক্টিভ করলে এটা ভুল হয় ইনটেক্ট এরর হয়
I'll hear you. I'll hear you. Do you also have a seat over there? Please sit. Please sit. Yes.
Now, academic score in clause K is nothing other than, Millard, the academic score spelled out in Millard Schedule 2, Part A2. Let us not go into all these things, whether with S and without S, it at all make any difference. But
S means the prior teaching experience.
Yes.
Without S is only the educational score.
But in that case, please consider one thing, Millard. What happens to the persons who do not have the teaching experience?
They don't get the marks.
They don't
either
get
at
the
this
marks.
stage or that
Yes.
stage.
Therefore, the stage is, Millard, when, Millard, I call them for interview, I have with me the marks which they are also entitled to by virtue of their experience. That is the purpose. If I exclude these people at the threshold by treating everybody equally, yes, at par,
Level playing ground. This is the
Millard,
judgment
level
of the
playing
Supreme
ground, in
Court.
my very respectful submission, this may not be applicable universally, because preferential treatment is acknowledged and applied in the service jurisprudence.
Yes. All right, then.
Therefore, Millard, if I give them these trained persons or the experienced persons, I go a bit forward by saying that I give them a preferential treatment by adding their marks at the time of preparation of this preliminary merit score, but I would be respectfully submitting that that is not infraction of any of the known principles of our constitution or the law of our country. Therefore, Millard, if a person is experienced, Millard, the experience has to be taken note of before calling them for interview and lecture demonstration. Now, the interpretation should be as I say. Why? Because if I do not give them, because it is said, please look into, Millard, the bracket portion. It is clarified, that is, from the written test or TET and academic score. Now, what they are trying to say is that academic and academics are different. Well, with respect, well, possibly well, it doesn't make any difference. Yes.
It makes a whole lot of difference.
No.
It makes a whole lot of difference, sir. This is the 10 marks issue is there in many matters. Madam, please sit. Please sit. I'll hear you. And now the stage at which it should be added.
2K. This is well my interpretation. Now let us come to 2L.
Yes.
Yes. Merit list in respect of SLST so and so means in case of post a list of candidates prepared category wise on the basis of merit, which shall mean in addition to what has been stated in 21K, marks obtained in oral interview, lecture demonstration and prior teaching experience, and shall include all eligible candidates who have appeared in the interview. Therefore, Millard, the prior teaching experience over at Millard L, Millard, if it is held or if it is interpreted to be at the L stage and not at the K stage, then Millard, it militates against Millard Schedule 2A2. And 6. But the rule by itself, the purpose of the rule is to give preference to the experienced candidates.
You give preference.
Yes. Therefore,
but then at what stage will
yes,
you give?
Millard, if I give them preference, I need to give them preference at the first stage or at the earliest stage. Because preference, the word preference itself presupposes that from the very beginning I'm going to separate both the classes.
Resources will not be augmented appropriately.
Yes. But preference cannot be Millard at the end. Preference has to be always Millard at the beginning.
Do you anticipate any candidate
Yes, ma'am.
who did not participate in the 2016 recruitment process to get this 10 marks?
More than 3,000 people have applied.
কতজন
More
করেছে?
than 3,000 of central government and more than 1,000 for the contractual teachers of substantive posts in state government. More than 4,000.
Applied.
3,000 plus 1,000.
3,000 which is central government.
To government and 3,000.
No, the figures, but I do not know, Millard, whether it will correct or not, but Millard, I am instructed to say
I do not need the exact figures.
Approximately 3,000 candidates with prior teaching experience from central government institutions, schools, etc. have applied, and 1,000 from
State government has provided a list of contractual teacher and substantive post of 1,000 teachers.
and contractual teachers
In substantive post.
in substantive post in state government institution around 1,000.
Applied.
They have
And
applied.
the total appointment is around 23,000 or how many?
35.
35,000. All right.
Very well, 35, 36 more or less.
Mm.
Therefore, Millard, if I have to give preference, well, there are two ways of interpreting it. What is the purpose? If the purpose is to make available good teachers, I have to give them preference at the beginning. Number two is, as they are arguing that this is creating a class between the two. Yes, we are creating a class.
No, the class is not in this matter.
The other,
Class is in
very,
class is
then Millard,
Right, class
yeah,
is
I don't,
not-
I don't.
We assume that the rule is all right.
Very well.
It is only the stage at which the 10 marks to be allotted is the issue.
First, to make available good teachers for the students.
In that stage also.
Yes.
That stage also you can make available good teachers.
No,
because you
no.
are adding at any case.
Millard, I am giving a preferential treatment, therefore preference has to be given
At the very first stage.
at
This
the-
is
at
the
the inception.
main submission.
At the inception.
That is the submission.
Then what is the purpose?
Millard, if Millard, the experienced candidates are Millard screened out or Millard
Why will they be screened out? Because they will get the chance at that level also.
if
Nobody
I-
is screened out at the 2K stage.
kindly look into Millard, the interview list.
Yes.
Millard, in the interview list, if Millard, these 3,000 or 4,000 are not there, and they have to wait, my lord.
Why will they not be there? That means their educational qualification score must be less. Otherwise, they would have been there.
My lord, I today, my lord, when at the time of framing of the rules, or my lord, at the time of invitation or the advertisement or the employment notification, I do not know anybody's score.
Nobody knows anybody's
Yes,
score.
therefore consider it from the stage or at the stage when my lord, an employment notification has been issued.
Right.
There, nobody is in the fray.
Nobody is in the
Nobody has applied.
Right.
We do not know the inter se merits of the candidates. At that stage, what should be the appropriate interpretation? Because the interpretation should not be, Miller, that the instance of persons who come before the court invoke the jurisdiction of the court, saying that I don't have the experience, therefore I'll be in the back seat always. That is what is being said. Now consider this, Miller, on two angles. One I have already said for the benefit of the students. The other is at the selection stage, I have to give preference or priority to those persons who are already experienced. The experience factor has to be taken note of at the earliest stage. It may, my lord, even be relegated back to, my lord, from the date of application itself. Because on the date of application itself, there are two, submission of application, or the last date of submission of, you have two sets of people. I can do that at that stage even.
I didn't get this. I didn't get this.
Yeah, I'll tell you. I'll explain it, my lord. I invite applications. 10,000 people apply. All the applications are with me. I have invited two categories of persons. Can I not distinguish between the experienced and not non-experienced persons at the very threshold after receipt of the applications? General, I'm speaking of general, hypothetically. Not Millard connected to this case.
No, when you seek application, you seek application from all.
All.
There, what you say that there will be a distinction between the
No,
candidates
I will invite applications from all.
Open advertisement.
All applies.
Yes.
Or two categories of people apply.
Right.
Can I not give
two categories means what?
With teaching experience, without teaching experience.
All right.
Now at this stage, this is hypothetical, not as per this.
Yes.
At that stage, after receipt of application, from that stage itself, Millard, the preferential treatment or the preference starts.
Provided your advertisement specifies so. It has to specify.
Advertisement may or may not be. Finally, the rules prevail. In case
that means the ruals, whatever you should have a substantive rule according to which you can say.
My reading of the rule is that the teaching experience has to be given at the time of assessment of the preliminary merit score.
All right. Yes, madam.
Just one. Just a minute.
Just. You want to make more submission?
Just 1 minute.
I think Mr. Bandopadhyay has
Just 1 minute. Just 1 minute.
I'll hear you.
The 5th August, sorry, I missed it. 5th August, Supreme Court has passed an order in the review petition. In that review petition, the Supreme Court has said the entire selection, therefore, had to be invalidated to maintain the sanctity of the process of selection, which should be pristine and free of all such infirmity. However, the interest of the appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluded paragraphs of the judgment. Greatest extent here means that this has to be protected. Experience. Now, this is the experience part is also there.
5th of August?
Pardon?
5th of August?
5th of August. 5th.
The supplementary affidavit has been filed as 5th.
Spiral compilation.
1 minute. 5th of August order is there?
Yes. Page 281. It's the spiral compilation. 281. 281.
Which portion did you read?
This is at paragraph 4.
Paragraph 4?
Paragraph 4, last few lines, above
Yes,
paragraph.
the adverse remarks.
The entire selection, therefore, had to be invalidated.
The entire selection. Yes.
Therefore, had to be invalidated to maintain the sanity of the process of selection. We should pristine and free of all such information. However,
the interest of the appointed candidates who are untainted were sought to be protected to the greatest extent as possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of the selection process is paramount and necessarily has to be given the highest priority. Last but not the least, the adverse remarks made against the authorities concerned, who are wholly and solely responsible for the adverse appearances of kind of until were fully warranted and justified. Now, my lord, the protection, this is
whatever is protected is protected. That nothing.
But,
Supreme Court has not given you anything else.
Here has not been clear, but this
Goes against you rather.
Protection to these 10 marks which have been given.
You give protection, but at what stage is the issue now?
Now, may I just take you, my lady, back to Schedule 2.
Schedule 2.
My lady's question on academics and academic score.
Yes.
Singular and plural.
Right.
Now, this is only English grammar. How are you in academics? Means English, math, so on and so forth. What is your academic performance? What is your academic score? That is the only distinction.
Tell me one thing. How are you interested in this matter?
No, I am in 4 IAs before you.
Yes.
Untainted candidates.
Maybe.
All of whom have prior experience. Now, I'll tell you, I'm answering my lady's second question.
Right.
You see, we all have prior experience. Some of us may have 3 years. Some of us may have 6 years. So, inter se in this category, if you even look at the rules, I may get 2 years for 1 year's experience. I may get 6 points for 3 years experience.
Right.
Now, please see. Now, please see. May I just take you back? We are just on interpretation right now. Not on merits. We're on interpretation.
Give a copy. Give a copy. There was direction for circulation of
correction. She is not even a party.
I am in items 9, 10, 11, 12, 14.
In 10, I have made him party.
Who have you served, madam? Who have you served? The councils are here.
There was a direction on the last occasion.
Yes.
Give copies of
Who
the
did you
affidavit
serve?
Give copies of the affidavit.
Who did you serve? The councils are there. Item 9, who did you serve?
10.
No, item 9.
9 and 10.
We are in 9, 10. They're identical, my lady.
Right, 9 and 10. Who did you serve? If there is no service, then I'm not going to hear you at all. Show me.
This is the service.
Please, onake dakhan.
9 and 10.
9 and 10, check out whether service has been affected or not. If not, please hand over copies. Yes, madam.
Yes. So on points of academics and academic score, because the rule could not have said academic score. It has to, it's a composite. It's just English grammar, my lady, nothing more. Academics has 2 components. So therefore, Schedule 2, the title, has to be academics because there are 2 components to it. Component 1 is educational qualification. Component 2 is the prior teaching experience. Both these are academics. If you ask my son, for instance, what are your academics like? What's your performance? And of course, he runs away when I ask him this. But it will be more than one. Math, English, PE, so on and so forth. What is your academic performance? What is your academic score? That is a composite. So it is only on English. It is not contradictory. Nothing needs to be read out. That's the first submission. Now, please see the second submission. Please go to prior teaching experience, 10 marks. My lady has that, Schedule 2. At the secondary level in a government or government-aided or government-sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or contractual basis. So this could include those who are not part of the 2016 recruitment cycle. This could include those who are part of it. This could include those who are in government teaching positions, or this could include those who are on contractual positions. So
No,
the
it's
net
all
is
right.
very wide.
All said and done.
Yes.
The stage. You get the marks.
Yes.
What stage?
Now the stage. Now please go to Rule 11.
Yes.
Rule 11 makes it clear, and then I'll come back to 2K and 2L. Rule 11, my lady has this.
Yes.
In my compilation, it's 541, but be that as it. Method of SLST for selection of candidates and preparation of the panel. The method for selection of candidates. Now, please turn the page over. Please see the sequencing that happens. Rule 10, this is 11, subclass 10, my lady. Preliminary list of shortlisted candidates, step 1. Thereafter, 11, regional commission shall verify the credentials. So at this point, I have taken the exam. I have given my educational qualifications, which are in academics. Please see, that is in schedule 2, academics. So at this stage, 11, there is a verification of schedule 2 that is happening. This is step 2. Step 3, 12. The regional commission during document verification in case of any doubt on disability. So any other specified categories, there may be other categories also. Step 4, so 3 continues. This is verification of documents. What documents? Educational qualifications. This is criterion 1 of academics. Now please go to 15. The central commission, regional commission submits these report to the central commission. The central commission, after we have finished this process of academics, which includes educational plus prior teaching. Now step 3. After this, the Central Commission shall prepare a consolidated interview list, which shall be published and be forwarded to the interview board. After academics has been assessed, this composite list, step 3, is sent to the interview board. Step 4, the final step. After the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list. This is the final stage. The culmination of 1 to 4 is step 5, which is the merit list, which, my lady, is L. That is the final stage. The rules are harmonious. We may have belabored its explanation, but the rules are in consonance with the steps which the rules provide for. It is in consonance with English grammar, and it is in consonance with the idea that a seminal idea which the Supreme Court has long upheld. It is within executive and legislative domain to fix qualifications. There is no preferential treatment here. We are choosing the best possible teachers. That includes educational qualifications, that includes prior teaching experience, that includes performance in the interview. Very well.
I have a direct answer for Lordship's
Yes.
question. When it will be, my first point is, it is absolutely clear when in the rule itself there may not be any requirement of any kind of interpretations. Kindly see first 11 Roman 8. Well, this is the substantive part of the rule. There is a difference between definitions for the purpose of finding out what does it mean and what is to be done. Now, what is to be done at 11.8, kindly look at two things, presence and absence. Presence of K and absence of L. So, 8 equals to, kindly, if I read, the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview. So therefore, pre-interview. So there is no confusion. Subject to verification of credentials, it's not relevant, and eligibility category-wise on the basis of, now this is preliminary merit score as defined in Rule 8.1a. Lordship conspicuously finds that it's not the definition of merit that is not there. The definition of interview list that is incorporated. And Lordship kindly come to straightway schedule itself. When Lordship's query is at what stage, 1 first, 2 second, 3 thereafter, 4, and that's the thing. Kindly follow that the simplest thing, schedule 2, A equals to capital A equals to the entirety what is required to be done. It's not what exactly pre-interview, all. Now 1, 2, 3, 4, kindly come 1. Exactly that was the beginning written, done. 2. Now 2 has 2 components. 2 has small a and small b. Now kindly see thereafter 3. So chronologically, this 3 for 9, 10 and also for 11, 12, it is coming after 2. If I just say once more, there is a clear chronology under the schedule. 1, 2, 3, 4. Yes, 4 ultimately ends at lecture demonstrations. So there, my lord, the oral interview comes as 3, whereas the prior teaching is coming under 2. So the question before your lordship is at what stage? It is at the stage of pre-interview because of the 2 reasons. Reason number 1.
When is the interview going to be held? Any idea, Commission?
Well, it has to be after the list is prepared.
That I understand. How soon are you expecting to prepare the interview list?
The verification process will go on for till 17th, 18th. I'll take
Till?
instruction and till 18th. I'll take instruction
Is
and
it after the 26th
I'll take instructions and
or before that? If the
tentative schedule,
The advertisement they have given, but
that is not being followed.
that is not being followed.
Assuming the Supreme Court interferes and says that 10 marks will not be there, as was submitted by Mr. Mitra on the last occasion, then the stage issue comes later on.
Stage issue, may I say?
Right.
May I just conclude? My lord, the stage issue can only come if there is any kind of confusion, as was sought to be said.
Now they are raising confusion.
Now they are raising, correct, they are raising. I'm not saying that they are not raising, but once lordship look at from this angle, when it is clearly said as 1, 2, 3, 4, and 3 equals to oral interview. Now then lordship has to somehow change this rule. I'm not saying that is impermissible, but that's a different thing altogether. As far as the
you say this is the chronology, they say that is the chronology.
No, I don't say the chronology is the only reason. I say this is the chronology. So the rule itself shows that before oral interview, it has to be calculated, number 1. Yes. And the direct answer is the substantive. The substantive says 11.8. I would be only praying before lordship to see the absence of L, because their entire submission is on the basis of definition of merit list. That comes later on. Lordship, kindly see that in Roman 8, there is an absence of. So therefore, how interview list has to be made, that is clear. Nobody is required to interpret it. They could have simply said, you also add the M. You also add the L. They have not. So where merit list comes, kindly look at Roman 16. Much after. And if you lordship kindly take the definition, it would be clear also. The merit list is something which comprises of everything if there is a requirement. It is not a double marking at all. Because for primary, that chronology is different for the prior teaching experience. That's they thought it. Kindly look at my lord, this K. So K is the clear answer. What should be the interview list? Number 1. And that says on the basis of the preliminary merit score. Now, where the preliminary merit score comes, is it before oral or after oral? Schedule 2 is clear. Now, their entire submission, if I take it, is they are banking on L. L equals to merit list. Now, if lordship kindly see a definition of the L, it is possible to say that there is some kind of, if I say, contradiction. But that is contradictions in the definition clause, not in the substantive clause. Substantive clause 11 Roman 8 clarifies that this list has to be done on the basis of the K and K only. And in that context, assuming that, my lord, there is a confusion, there is a direct judgment. That this judgment, my lord, takes this part. Kindly take the definition clause 2. This is the kind of rule which begins with 2.1. Kindly take, my lord, 2.1. In these rules,
I'll fix this matter later on. Please come. Heard submissions made on behalf of the parties, including the applicants, interveners at length. Stop. Release the matter once again on 28th of November 2025. Supplementary affidavit filed on behalf of the petitioner in the matter of Rahul Mondal and others.
Let them prepare the list, but not for
Be taken on record. Stop. Next.
যেটা দিলে তখন না তো রুলস আমি ম্যানেজ
In the last day's order, it has been recorded that the fate of the examination will abide by the result of the writ petition. That order remains. So that order continues. And just wait for the Supreme Court to make any type of interpretation, or if you all can get hold of any one line which says that this court can go into all these things, then with an open mind, the court can decide. Otherwise, it's always playing at the back of the mind that anything will touch that 10 marks.
Yes.
Anything, any order passed here will touch that 10 marks issue.
But this issue would never be gone by the Supreme Court.
Suppose the court says that the 10 marks will not be there at all.
That is fundamental.
That is the main thing. Then no question of former, later, now, later.
But if the Supreme Court says...
Right, then this is there and the interim order is also there.
Okay,
10 marks, they can always calculate. Let us see.
Already in order to abide by, there is no reason.
Yes.
And this is not that kind of matter that they can seek a stay of entire proceedings.
Nothing of that.
On
Yes.
20th November, one clarification. Will my lord hear me or not?
I will certainly hear you.
Then he will.
I have heard you. Today also I have heard you. And I'll hear you on the next day
I
also.
would have avoided all the complications.
You have, sir.
How to read a statute? That's
Yes.
the only question.
Yes, sir.
That's
Next day. এক minute. 9. Yes. For what? No, sir. You must be filing your intervention application. That is on record. What affidavit will you file? What affidavit will you file? Your application is in your support. What further application will you file? Don't add up documents. All right. Can যতগুলো আছে না allow করে দেব.
My lady, just one
The
small
documents
point.
to be circulated, did you interveners?
Yes.
What about the copies? Did you get it? Copies?
Yes.
Other cans?
My lord, I have not received.
See, somebody
will
has not
please
received.
give
Please
copies.
give.
Can.
Please give.
Don't be stingy on photocopy.
To
Give
avoid...
copies.
We are involved with the 4 matters, my lord. All the matters we have solved and I have the affidavit of service management.
See, the court is not concerned with the affidavit.
My lord, any of the matters.
Papers should be there. The court is happy.
Hand
A
over.
question of law.
Copies.
But to avoid further confusion, logically record note, this issue does not relate to the constitutional validity, but relates to the applicability of the rules.
Last day's order, what is the issue is clearly recorded. I will not add anything.
My lady, my submissions are for all the cans that I'm appearing in, my
I'm
lady.
very ill
So
experienced before
you
the Supreme
file it
Court.
today, you file it on the next day, it will be the same thing.
Yes, so it's the same submissions for all of them. We've got them very briefly for my lady's consideration.
Give it. It is the same thing.
Yeah, it's the same thing in all the cans.
Same order will go down in item number 10.
My lord, only one thing, your lordship is allowing these
9, 10,
applications.
11, 12, 14.
They'll
Then, my
let
lord-
be added because I'm hearing them.
Yes, my lord, only one thing, then department may be directed to amend the cost title because
cost title amend করবে intervention
Right now,
এই হিসেবে
intervention হিসেবে থাকছে
let them remain. Let them remain. They have been allowed to participate in the proceeding. The court has heard them.
Yes.
Right?
My lady, I hope I'll be able to come back to my lady's court.
Please
Hopefully,
do.
That's
And
my,
enjoy the city.
That's my hope. Yes, I'm
It's
grateful.
a nice weather right
Beautiful
now.
city.
Please do.
Grateful.
আমি জানি না
take the item number 5.
5 and 6. These SSC's matters are over, isn't it?
There is only item
Oh.
13. Similar thing in a different way.
13 has been marked. 13 is the same thing.
14 is
14
is a B and group C.
13th has been already fixed. Order হয়ে গেছে তো 13 তে? 13 হয়ে গেছে। 14, right?
13 is different.
14 is
14 is, my lady,
না, দাঁড়ান।
14 is segregation within the class.
Which one? 14?
14.
Who are the applicants? Please check up. Give a phone call. Then serve copies. Please serve.
I want to argue because either for the unlimited teacher of 11, 12, I am glad. The rule is specifically qualification and voter selection is the difference. So, whether
Can number 1
is eligible, but the teaching experience marks for the 11, 12 course. They have applied because one of the rule is there, but there is the two categories. If the 9, 10 the untainted teacher applied in the 9, 10 school and 11, 12, if the marks will be given for the both, so double benefit will be given. That is our contention. We are the untainted teacher for the 11, 12. So, the rule is the
You do not want the 9, 10 teachers' experience to be counted. Or 11, 12.
Because the rule is the different and education quality is the difference and selection process is the different. So, school service commission, what to stand?
All right. Let us wait and see whether the Supreme Court upholds the 2016 rules or the 2025 rules. If the court upholds 2016, then all goes. If 2025 is upheld, then the court will look into all these things.
One thing is, kindly recorded my submission and if the 19 teachers will get the benefit for the 11, 12 course because they will get benefit for the one class. If they will be benefit for the two classes, but double benefit will be given. But that is not permissible under the law.
Listen. A candidate will get one selection either in 9, 10 or 11, 12. Right? Now you say that their experience in 9, 10 cannot be counted for 11, 12. This is exactly your submission.
Because
right.
They are the untainted for the 9, 10.
We are right now not in tainted and untainted. Right now the issue is whether 9, 10 qualification can be taken up for consideration for teaching classes 11 and 12.
They have no experience in the 11, 12.
They have no experience in 11, 12. Item number 14 এ একটা order লিখুন তো। The petitioners raise an issue.
But I also have an application.
With regard to the
Order
selection process initiated by the West Bengal Central School Service Commission for appointment of assistant teachers in accordance with the rules and নামটা একটু দেখে নেবেন তো 2025 rules. ঠিক আছে? Submission is that the authority cannot take into consideration the experience of candidates teaching 9 and 10 for recruitment in classes 11 and 12. This exactly is the issue.
But I have can 2.
I have can 1, item 14.
All right. The broad issue as to whether the 2025 recruitment process can be adopted for the recruitment or the 2016 rules will apply is pending consideration before the Honorable Supreme Court. Stop. It has been brought to the notice of the court that the matters are fixed before the Honorable Supreme Court on the 24th and 26th of November 2025. Stop. Next. Let this matter be posted on 28th November 2025. Stop. There are several intervening applications in the instant writ petition. Stop. Let copy of all the intervening applications be served upon the learned advocate representing the petitioner. Stop. The copies of the applications
which
shall
not yet
also
served.
be circulated amongst the parties. If served, then there is no reason for double service. Just ensure everybody has all documents, nothing more. Yes. Yes.
Only one right in your lordship order.
Which order?
The last
14.
Just one. Whether 2016 rules or 25 rules, there are other issues also. Just add, if it comments to your lordship.
Where?
In your
Which
lordship
matter?
order, in the honorable Supreme Court, all issues are covered.
Whatever is there before the court is
Your
there.
lordship is pleased to record, whether this rule or that rule.
Yes.
That particular
That will cover everything. No, nothing. 5 and 6.
Challenge before the Supreme.
Yeah, that was the submission I have recorded.
25 rules specifically is there.
Yes, item 11 to hoye gache.
And item 11 in the same order.
Yes.
13 is
only item 13 it will be different because it is for group D and C, which is
non-teaching.
Group D and group C. Here it is not a teaching experience, similar experience.
And it's
Now,
different
so
rules.
therefore,
And the issue
this
is different.
not there before the Honorable Supreme Court. But I don't know whether Lordship wants to hear it now or
Item
This is a
13.
separate rule.
item
Issue
13.
is
There is
separate.
a separate rule.
The counsel for the petitioner agreed to pass the same order in respect of 4, 7 and 13 has been tagged.
Done so incorrectly because
Then if the petitioner has done it incorrectly, let the petitioner do it. Let it be.
only thing there is
Canta.
there is an addition in party in item 13. If there is a one line is that.
Can 1, 2 is there.
I appear for the can 2. আমরা can 1.
Can 2.
Can 1 আমাদের।
Can
আমাদের
1.
Application of addition of party. Item number 13. আচ্ছা 13 এ একটা লাইন লিখে নিন। The
Different rule. Not the same.
Learned advocate representing the interveners have been heard. Stop. The interveners will be heard on the next day also. Yes. All up.
This is the affidavit of service, my lord.
Yes.
This is a question of, my lord, the higher scale of pay. The petitioner first has been appointed, my lord,
5 and 6. I mean 6 here.
in a
This
school.
is there. Other side is there.
Item number 5, my lord, Mr. Biswajit Dey is appearing. He is engaged in another courtroom, my lord.
My lord, your lordship kindly take this matter up at 2. Both
1
these
minute. 1 minute.
6 years.
So 118, it's past recess. The courts are sitting. Yes, come to us now. What is the matter?
My lord, petitioner, my lord, after getting appointment in a school under the Bardhaman, my lord, thereafter he passed the MA examination. And my lord, thereafter he seeks.
Postgraduate scale of pay. Where is your application?
My lord, there is two applications, one in the district of Bardhaman and thereafter.
Has it been considered?
No, my lord.
No.
Thereafter, she has been transferred to the Howrah.
Yes.
And my lord, thereafter, he again made an application before the district inspector of schools. My lord, let it be considered.
Page.
My lord, prayer for my lord, that is page 57, the last application.
The petitioner
My lord,
seeks
within
higher
the
scale
time
of
bar.
pay. Stop. Her application seeking higher scale of pay is pending consideration before the District Inspector of Schools,
AC Howrah.
Secondary Education, Howrah. Page 57.
Yes, my lord. Annexure P21.
I have got only 56 pages, but your application is here. Acha. Without entering into the merit of the same, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Howrah, to consider the petitioner's prayer in accordance with law and in line with the judgment laid down by the special bench of this court in the matter of Utpal Kanti Koron and others versus State of West Bengal and others, reported in 2024 SCC Online Cal 1274. At the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Now I take it 12 weeks. Korun. An opportunity of hearing shall be provided to the petitioner for production of all documents in support of her prayer. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken by the said authority. Disposed. Service is taken on record. Yes. Next one is also same.
No, my lord. This
Different.
is
What is it?
my lord, this is my lord, regarding my lord, the CPF to GPF.
Yes.
My lord, the widow has come to before your lordship because my lord, the pension my lord has been
You
given.
got similar order?
My lord, I have done.
Please give.
My lord, it has also been corrected in my way.
All right, all right. Who are you for the state? All right.
আমি তোকে একটা কথা correction করে দিই।
From the date of
There are similar orders for widows also.
from the date of
My
return.
lord, I have corrected that wherein the husband, I have corrected the widow. Every page I have corrected. I have carefully corrected.
আমাদের কাছে widow আছে CPF GPF widow.
From the date of retirement.
My lord, from the date of retirement, he paid for date of retirement. That was not paid to the original petitioner. Original, my lord, the pensioner.
এখানে একটা দিয়েছে, আমাদেরটা দেখে নেবেন আর এটা দেখবেন, সেম হলে দিয়ে দেবেন. Disposed.
Grateful. You have service in both the case.